Hello, Matthew Bell here. Today I wanted to talk to you about 7 different things that have been changed because of the Secure Act that was recently passed by Congress and signed into law by President Trump. So first of all, the Secure Act stands for, and you know how Congress loves to name these acts, Secure Act stands for Setting Every Community Up for Retirement Enhancement Act. So the Secure Act. Some of these consequences and changes that have been made, I'm just going to kind of gloss over. Others will dwell a little bit more fully on, and perhaps we may even deal with a few of these in greater detail in another place. Change number 1, the Secure Act expands the availability of tax-advantaged retirement plans for small businesses and small business owners. Number 2, it expands 401k participation to include those people who are part-time. Part-time employees as defined as they have worked 1,000 hours in a year or they've worked at least 500 hours in 3 consecutive years. Number 3, it allows 529 plans to be used to pay back student loans, which is kind of interesting because now the 529 plans can be used to help pay for college in advance, or you can fund them in advance of college. You can use them to pay for college as it's happening, but now because of this change, in some cases you can actually use the 529 to pay for college loan payments, which enables you to help pay for kids, grandkids' college after they've already gone. Now, as with any of these, I am not a financial advisor. I cannot give you direct advice. In order to explore the ins and outs of these things, you're going to have to consult a licensed professional in your area, somebody familiar with these various plans. So check out the particulars of your plan. You would contact your plan administrator or your financial advisor. Number 4, the Secure Act has allowed for an early withdrawal option for people who are paying for adoption or who have a new child. And that allows, so let's say you have a married situation, each spouse then can withdraw $5,000 from their 401k without a penalty. So you may be aware that there's a 59.5 rule, which basically says that you cannot take a penalty-free withdrawal from your retirement account until you hit the age of 59.5. Now, there are a few exceptions to that already. For example, first-time home buyer, certain medical emergencies, and other things along the lines of that. If the person dies, of course, then there's other rules would apply. There's also a 55 rule, which basically indicates that if a person has severed employment ties, so let's say they get fired, they get terminated, they retire early, in some cases they can also take penalty-free withdrawals as early as 55. But in this case, it carves out another exception, again for adoption. $5,000 is the exception per person, so in a married couple situation, they would be able to get a total of $10,000. Now, you should be aware, as always, taking a withdrawal from the 401k or from your retirement plan in general may be permissible. You may be able to qualify for an exception, but it isn't necessarily a good idea simply because it is going to put you back in terms of retirement savings, and you're going to miss out on some of that long-term growth potential that your money is in the 401k for in the first place. Of course, in certain situations it's unavoidable, and it's good to know at least that you have that option. Now we're going to get into some of the changes that affect retirement planning a little bit more specifically. So the first one that I'll note is that up until now, up until the passage of the Secure Act, IRAs, that is individual retirement accounts or individual retirement annuities, could be funded up to age 70.5, but not beyond that, even if the person whose IRA it is still working. To fund a retirement account, like an IRA, a Roth IRA, a 401k, you have to have earned income the year that you contribute. But in the case of the traditional IRA, there was a hard limit on contributions up until age 70.5. The Secure Act does away with that, so now you can continue to fund 401k, traditional IRA, and Roth IRA even past the age of 70.5, provided that you have earned income the year that you're trying to contribute. In other words, provided that you're still working. Now, what vehicle you contribute to is going to be a function of what your tax situation is and some other things. I get into this a little bit more fully in another video, but again, I'm not a tax preparer. I can't give you tax advice. I can simply say that because these vehicles are taxed differently, the traditional IRA, for example, and the Roth IRA are taxed differently, you want to weigh the possibility that one or other might be more advantageous for you in your situation. Another major change, and this would be number 6, that was number 5 then, so number 5 was contributions to an IRA past 70.5. Change number 6 is that the required minimum distribution age has been pushed back from 70.5 to 72. So up until the passage of the Secure Act, at the age of 59 and a half, you may start taking money out of your retirement accounts, and at 70 and a half, qualified accounts, for example, the 401k, 403b, 457b, also the traditional IRA, the owners of those accounts at age 70 and a half had to, prior to the passage of the Secure Act, begin taking distributions and essentially settling up the tax on those accounts. Now, I get into this more fully in other places. At least I treat the idea of the RMD, but you're going to have to remember that because of this change, there is that change that's been made. So it's no longer a 70 and a half rule. It's now at the age of 72, you're required to start taking money out. Now, the on the surface reason for the change is that life expectancies are different than they were. People are living longer, and so on the surface, the idea here is that pushing the RMD back is supposed to help preserve money for a little bit longer, to help people propel themselves further into retirement because their life expectancies are longer. However, another consequence of this is going to be that, for one thing, a number of people who wouldn't touch their money at age 70 and a half were it not for the RMD now are going to have the option to push it back to 72. This is going to tend to have the consequence of leaving more money in retirement accounts to be passed on to beneficiaries when the person dies. And so it is a plausible, intuitive, not definite, but it is an intuitive consequence that the further we push the RMD back, the more money is going to get passed on to beneficiaries in the IRA account. In other words, the more money that's going to be in the account when the owner dies. Now that means for a non-spousal beneficiary, there's also going to be a tax liability that gets passed with the money. A non-spousal beneficiary essentially has the option to take the account, take ownership of the account as if it were his or her own. But in a non-spousal beneficiary situation, then there is a tax bill that's at least due. In the past, and this is the final that we'll treat here, the final change that the Secure Act made, number 7, is in the past a inherited IRA that went to a non-spousal beneficiary had a couple of different options. It was possible to liquidate the account, that is to say, fully distribute it over the course of 5 years. It was also the case that beneficiaries had the option to stretch the distributions over their life expectancy. And there was a particular life expectancy table that's formulated by the Internal Revenue Service for the purpose of being applied to inherited IRAs in non-spousal situations. That has now been eliminated. So the stretch IRA is now no more. It is not possible to take distributions of an inherited IRA over a person's lifetime. Now, any account that already had been a stretch IRA is not changed because of this law. They're grandfathered. But anybody who dies starting January the 1st, 2020, and leaves an IRA to a non-spousal beneficiary, that non-spousal beneficiary is now going to be covered by the rules stipulated in the Secure Act, and that stipulates that the account has to be liquidated over the course of 10 years. So if you inherit an IRA in a non-spousal situation, you've got 10 years to do a complete distribution of all the money in that account. So if you just think $1 million, you can take it all out year 1. Probably wouldn't be a good idea. You could take it all out year 10, but most likely you're going to carve it up into 10 different payments to try and minimize the impact. And so with respect to $1 million IRA that gets passed on, obviously $100,000 a year is likely to impose on that recipient a bump in their tax bracket, which is going to translate to a higher tax bill. Now, there can be a number of strategies for trying to mitigate or reduce this impact, and now is not the place that I'll get into this. Suffice it to say that there are some strategies that people are recommending now. I'm not a tax preparer, but I will get into some of those strategies in a subsequent video. So if you're interested, I would invite you to stay tuned for that. If you found something of use in this video, I please ask you to like the video, subscribe to the channel, click the notification bell to be alerted to new content as it becomes available. I thank you so much for joining me today, and I look forward to seeing you again in another video. Thank you.